Good morning, everyone, and welcome to another Radcliffe Chambers Junior Programme webinar. I'm Matt Mills, and joining me in the commentary box is Amber Turner. Good morning, Amber.
Morning, everyone.
Today, we'll be talking to you about two current topics in charity law. Amber will speak first about the rules governing charity campaigning during an election season, and then I will speak about the rules relating to ex gratia payments. After that, we'd be happy to take any questions from you. If you'd like to ask a question, please click on the Q&A box at the bottom of your screen and type your question there. Don't worry, only Amber and I can see what you say. Without further ado, I'll hand over to Amber.
Thank you very much, Matt. Okay, I think my slides are just loading. Great. So good morning again, everyone. Thank you for coming today. As I'm sure you're all aware, we are expecting a general election this year, as well as local elections in May, including the election of the Mayor of London. Elections are a time for policy discussion, and as such, they're a great opportunity for charities to get the issues that they advocate for on the agenda and to generate debate. However, they're also a time when charities will need to be careful to remain independent and, importantly, to be seen to be independent from political parties. In light of that, today I'm going to be talking through the key points that charities will need to bear in mind this election year. So as I was saying, elections are a time when debates about particular issues are amplified, but for charities and their beneficiaries, these are issues that they're dealing with all the time. So I'm going to begin by talking about the rules which apply to campaigning and political activity by charities generally, and then look at particular things to be aware of during an election period. Today I'm using the terms campaigning and political activity. Both of these terms have been given specific meanings by the Charity Commission in the guidance that I'm going to be referring to, which the Charity Commission has helpfully produced on these matters. So let's take a look first at what they include. Firstly, campaigning. Now, it's important to note that this is separate from what we call fundraising campaigns, which are a different topic and we won't be talking about today. Campaigning, in the sense we're talking about today, covers two types of activity. Firstly, it covers efforts to increase or raise public awareness about issues, or to educate the public, rally support, or influence or change public attitudes. An example that the Charity Commission gives of campaigning, in this sense, is a health charity promoting the benefits of a balanced diet in reducing heart problems. The second type of activity covered is activity which aims to encourage or ensure compliance with or observance of existing laws and policies. Again, the Charity Commission gives an example of this kind of campaigning, of a disability charity pushing for existing legislation to be complied with to make sure children with special educational needs get the support that they're already entitled to under legislation. Political campaigning or activity, on the other hand, is activity which is designed to change or influence policies or decisions taken by governments and public bodies. It's important to note that when we talk about governments and public bodies in this sense, that includes national, local and overseas bodies like the UN, for example, or foreign governments, as well as national or local organisations like regulators or NHS trusts. So specifically in relation to political activity, that's activity which is aimed at securing or opposing any change in the law or any policy of central government, local authority or public body in the UK or abroad. And again, it's worth noting that that's different from campaigning to ensure compliance with the current law, which falls under campaigning. So let's have a think about what the attitude of the Commission is to campaigning and political activity. Now, the most recent guidance notes that the instinct of a lot of charities might be to avoid campaigning rather than to risk falling on the wrong side of the line. The Commission recognises this, and the quote on the slide gives an indication of its general attitude. Charities are free to campaign, and they can expect the Commission's support if they choose to campaign. The current version of CC9, which is the applicable guidance to this area, notes that the Commission had noticed some charities had been overly cautious and were self-censoring their campaigning activity. The Commission wanted with this new guidance to encourage charities to be more confident about what they can do. And so the guidance itself focuses on freedoms and possibilities first, and then on restrictions and risks, which of course charities do need to be aware of. So practically speaking, what should a charity thinking about campaigning or engaging in political activity do first? Well, as so often, the answer is that the starting point should be the charity's governing documents. The specific things to look out for are, firstly, is there a specific power relating to campaigning or political activity in the governing documents? It's not necessary for that power to be there in order to allow a charity to take part in that kind of activity, but it might be helpful if it's in there and if it sets out the parameters for how that kind of activity can be done by the charity. Secondly, is there a restriction in the governing documents which specifically prevents the charity from campaigning or from engaging in political activity? If that's the case, then there's no getting around it, and the rest of what I'm going to say doesn't apply. And then finally, it's crucial that campaigning and political activity is always conducted in line with the charity's purposes. So those purposes are a really important anchor for the trustees to keep coming back to when they're thinking about doing campaigning and political activity. And they should always be asking themselves, does this activity further the charity's purposes? And is it an effective way of doing so? On purposes, the Charity Commission guidance makes this point clearly, saying political campaigning and activity must only be undertaken in the context of supporting the delivery of the charity's charitable purposes. A side note here is that an organisation will not be charitable or capable of being registered as charitable if any of its purposes are political. The Charity Commission defines this as any purpose directed at furthering the interests of any party or securing or opposing a change in the law, policy or decisions in the UK or abroad. So that's something to bear in mind if you're advising an organisation seeking registration or a founder looking to set up a charity. If they want the organisation to engage in political activity in service of its charitable purposes, that's fine, and it would be better served by a power in the governing document. But if the specific aim is to change the law on a particular issue, then it's not going to be capable of being a charity. The key question, as I've already hinted at, for the trustees to ask themselves when thinking about engaging in this kind of activity, is there a reasonable expectation that political activity will support the charity's purposes? The usual rules about trustees' decision-making apply and should be followed. And of course, if the answer to this question is no, then it will not be appropriate for the charity to engage in political activity. Another key thing for trustees to bear in mind in this area generally is that even if they are satisfied that political activity will support the charity's purposes and is an effective way of doing so, they must not allow it to become the reason for the charity's existence or the sole and continuing activity of the charity. It may be an effective way of supporting or furthering the charity's purposes, and at a particular moment in time, it may be the best way, and that may justify it being the sole focus of the charity. But that must not become permanent, and thought should always be given to whether other methods would be effective or more effective. Now, one of the ways in which a charity might engage in political activity is by supporting or advocating for a particular policy. That's fine, and it's fine even if it's a policy which is also advocated for by a particular political party or candidate. However, the charity must not go further and support that party or candidate. The key thing is to support policies, not parties. Another way of engaging in political activity could be attending or contributing to debates. Again, that's fine, and a charity can try to influence the policies of parties in the interest of its beneficiaries, but it must not assist any party to be elected. Charities can accept invitations or even reach out to all the major political parties to advocate on a policy. But if it engages with only one of them, or a couple but in a particular part of the political spectrum, this will call into question the charity's neutrality, which is essential. So when engaging with political parties, neutrality is essential, as I've just said. Independence is essential. The charity must both be independent and be seen to be independent. The Commission is clear that supporting a party is not an acceptable form of political activity for a charity. The same goes for a particular candidate or individual politician. It's open to a charity to engage with political parties, but it should always consider working with multiple parties to maintain neutrality. Aside from this, it makes sense for charities to engage with multiple parties. You can never guarantee who's going to win an election, and getting stuck with an opposition ally isn't likely to get the charity's favourite policies on the statute books anytime soon. So there are both practical and legal reasons for taking this position. So now that we've looked at campaigning and political activity generally, where does that leave us this election year? CC9, which I've quoted on the slide, points out that the need for impartiality is intensified and charities will need to take particular care when they're engaging in political activity during an election period. So when is the election period? Well, it starts when an election is announced and it ends on the date that the election is held. It's also important to note that both national and local elections are covered by the Commission's guidance, and there's also a specific section dealing with referendums, which I won't be looking at today. I've been talking a lot about CC9, which is the general campaigning and political activity guidance. There is then a separate guidance produced by the Commission, which relates specifically to elections and referendums, and should be considered in addition to CC9. The guiding principles during an election follow on from the principles we've been looking at already. Firstly, charities must be seen to be independent from party politics. And secondly, whilst charities can attempt to influence public opinion on a particular issue, if it furthers or supports their purposes, they must then leave it to the electorate to make their own decisions about how to vote. So during elections, we often get the clearest idea of parties' policies, if we're lucky anyway. So it's a time when comparisons between a charity's policies and a party's might naturally be made. The important points for charities to remember during these periods are that it's fine to keep advocating for the charity's policies, but it's important to ensure independence from parties which are advocating for the same policies. In particular, charities should refrain from making comparisons between their own policies and those of the political parties, and that's the case whether it's a positive or a negative comparison that's being made. These principles apply when the charity is drawing up any publicity materials. And the Charity Commission gives the example of a housing charity which supports the building of 100,000 new homes. That charity can outline the housing policies of each party in its publicity materials, including how many new homes each party has committed to building. But it must not explicitly call on people to vote for one party or another on the basis of those policies or otherwise. Charities may wish to and are free to produce their own manifestos, which set out their positions on issues relating to their purposes. That's fine, and it might be a good opportunity to raise the profile or publicity of the charity, as long as the intention is to advocate for a policy or raise the profile of a particular issue, but not if the intention is to influence voter behaviour in any way. So any manifesto must not seek to do that. On manifestos generally, if a charity is approached and asked to feature in a particular party's manifesto for the election, it must refuse, so as to avoid the impression that it endorses that particular party. When it comes to parties and candidates, charities must not support or oppose parties or candidates. This is so even if in one constituency they're supporting a Labour candidate and in another they're supporting a Conservative candidate. This highlights the fact that it's not just impartiality and neutrality which are being considered here. Another major restriction on the charities is that they must not seek to influence voter behaviour, even if they're doing so in a balanced or neutral manner. Secondly, charities must not donate funds to any party or individual campaigns, and they must not assist with those campaigns in any non-financial way either. If a charity decides to hold a meeting or a debate with a view to raising public awareness about an issue on which it's campaigning, which again it's entitled to do, It must make sure it's not encouraging support for any particular party or candidate. One way of managing the risk when holding these kinds of debates is to invite candidates from a broad political spectrum. There are a number of factors to be considered, however. If it's a small charity and there's only a small space available, is it practical to invite all the candidates? Well, it might not be. In that situation, the Charity Commission envisages that all minority parties might be excluded. There's also a consideration about whether a particular candidate's views contravene the charity's purposes. Now, if that's the case, it is open to the charity not to invite them, but the Charity Commission makes clear that a charity would need to have very strong reasons for not inviting a candidate from a mainstream political party. So that's another thing to bear in mind. Finally, in relation to parties and candidates, there may be conflicts of interest to be managed. For example, if an employee of the charity is standing as a candidate for election, which might be a particular issue in relation to local elections, the trustees should be made aware of this, and the conflict and the risk to the charity's reputation should be borne in mind, as well as any legal liability that the person who's operating in those dual roles might be open to. For some charities, elections mean that they're also called upon to make their facilities available for meetings for free under electoral law. Now, charities, and in particular some schools to whom this applies, need to be aware of their obligations. Other charities who are not required to make their premises available, but may be asked to do so on a commercial basis, should treat such requests as normal commercial hires. They should not discriminate between parties. Now, whether that's in refusing a request or in charging different rates depending on who is asking. But it is open to a charity to refuse the hire if there's good reason to believe that by hiring to that particular person or group, they might alienate the charity's beneficiaries, users, or supporters, or where they're advised by the police of a risk of public disorder. But those decisions need to be looked at with some care. Now, so far, I've been looking at the applicable charity law, but there are also electoral law and local government law considerations which arise out of political activity by charities. Now, these aren't the subject of this talk, so I'm only flagging these particular questions that charities should consider. In terms of electoral law, is there a need to register as a non-party campaigner with the Electoral Commission? The Charity Commission guidance helpfully provides links to the relevant legislation and the Electoral Commission website. And this would tend to depend on the amount of money that's been spent on campaigning and what kind of campaigning the charity is doing, but it needs to be looked at on a case-by-case basis. Secondly, does the charity receive any local government funding? If so, the charity might find itself subject to the same restrictions that local authorities are subject to. So, publishing any material that appears to be designed to influence public support for or against a political party may put its funding at risk because the local authority isn't able to do that itself, and that extends to organisations which they fund. So, after that whirlwind tour, let's just recap some top tips. Now, as always, be guided by the charity's purposes. Ask if the activity that you're proposing furthers the charity's purposes, and ask if it's an effective way of doing so. Always remembering that political activity cannot be the only way in which a charity pursues its charitable purposes, and it cannot become the sole and continuing activity of the charity. Secondly, make sure that staff and volunteers are aware of the restrictions. It could only take one person who hasn't had the proper training or information doing something completely well-meaning to open the charity up to criticism. Finally, know where to look and find the guidance. It is written in a very trustee-friendly way. There's plenty of examples and questions and answers, and actually CC9 has a helpful checklist at the end for trustees to go through when they're considering engaging in this kind of activity. Finally, before we end things, some warnings. Now, the main thing, as I think I've reiterated, do not be party political. Be and be seen to be independent. The second thing, Don't be exploited. Now, I think this applies particularly to small charities for whom an offer to engage with a political party might seem like a great opportunity for the charity and its beneficiaries to get a raised profile and to speak more publicly about the problems that they face. It's very important that trustees understand their obligations so that they don't find themselves being pulled into situations like that, particularly as we talked about with perhaps being mentioned in a party's manifesto. Finally, don't forget that political activity is not the be-all and end-all. Other activities and regular campaigning are important too, and as we've seen, while it may be appropriate to focus most or all of the charity's resources on political activity for a period, and an election period seems an obvious time for that, it must not become the reason for the charity's existence. So remember, after the elections are over, including the big one, to take stock and return to normal business. Thank you very much. I will now hand over to Matt. As he said at the beginning, if you do have any questions, we're going to deal with those after both talks are finished. And let Matt take it away.
Thank you very much, Amber. Ladies and gentlemen, my talk today is about ex gratia payments, because I all know you love a bit of Latin on a Wednesday morning. But my talk will have 4 parts. Firstly, I'll explain what is and what isn't an ex gratia payment. Secondly, I'll explain when ex gratia payments are allowed. Thirdly, I'll explain the 3 routes by which charity trustees can currently get approval for an ex gratia payment. And fourthly, I'll summarise the upcoming changes that the Charities Act 2022 will introduce later this year. Let's get cracking. First things first, we need to know what on earth an ex gratia payment is. Literally, ex gratia means out of thanks, which is a very unhelpful definition. More unhelpfully, there is no official legal definition of the phrase ex gratia payment, but it's generally accepted that it's a payment that meets the following 3 criteria. The trustees believe they're under a moral obligation to make it, even though they're not under a legal obligation to do so, and the payment cannot be justified by reference to the interests of charity. Now, I don't want to get lost in the depths of philosophy and ethics so early in the morning, but an Irish case has attempted to give us a definition of a moral obligation. It's rather long-winded, but when you really boil it down, it's basically an obligation imposed by conscience or honour rather than by the law. One final point to note is, although this talk is called ex gratia payments, the same principles apply to transfers of other assets and indeed to the waiver of the right to receive any assets. But for simplicity, I'll just say ex gratia payments, but it covers all 3. So that's basically what an ex gratia payment is. It's really important not to confuse these with 3 other similar types of payments that charities may make. Firstly, voluntary payments which are authorised by the express or implied terms of the governing document. For example, if the proposed recipient is a beneficiary of the charity, the trustees may be able to make the payment in the ordinary course of the charity's activities. That's not an ex gratia payment. Secondly, voluntary payments which are in the best interest of the charity or good for business can be legitimate. For example, it may be good for business for a charity to give retiring staff members a slightly larger pension than they're entitled to, or to offer slightly larger redundancy payments to people who are made redundant. Another example might be that it's expedient for the charity to make a particular payment to a very important living donor. These aren't technically ex gratia payments. A third similar type of situation is a payment to settle existing or threatened proceedings against the charity. The Charity Commission puts it, an ex gratia payment is not a soft option to settle litigation. It's an entirely separate doctrine based on moral obligations only. Now, although these aren't technically ex gratia payments, in situations 2 and 3, it might still be advisable for the trustees to get the Commission to authorise the payment under Section 105 of the Charities Act. Finally, on this issue, don't forget that the Charity Commission has recently published some updated general guidance on accepting, refusing, and returning donations. This doesn't directly relate to ex gratia payments, but because it's in the same field, I thought I'd put it on your radar. Is there an upper or a lower limit to what counts as an ex gratia payment? In short, no. There is no limit, upper or lower, on an ex gratia payment. The principles I'm about to describe apply to a payment of any amount. However, in practice, the Charity Commission is unlikely to challenge a payment which is for £1,000 or less. And similarly, it's unlikely that small and inexpensive items like bouquets of flowers and boxes of chocolates and thank you cards are ever going to be considered ex gratia payments. So that's what an ex gratia payment is and isn't. But when can a charity make one? The first and leading reported case on this issue is re Snowdon. As you can tell by the name, Mr. Justice Cross heard two cases at the same time. In the first, Norman Snowdon's will had left his shares in 3 charities to his nearest relatives. He then made some modest bequests to some charities, and the residuary estate was divided between the charities. Before he died, he sold those shares for £125,000. That meant the gift of the shares are deemed, and the charities got £125,000 more than they were expecting. In modern money, that's about 1.8 million. Most of the charities accepted that they should pay between 30 and 75% of their residuary legacy to those next of kin. The second case concerned the will of Florence Henderson. This was a short handwritten document where she'd made some legacies to her family members and then said anything over to charities. On an unknown date, though, she'd added in red ink the words half each of my shares next to the names of her niece and nephew. But because it couldn't be proved when those words were added, those words were not admitted to probate. So the shares fell into the residuary estate and went to the charities. Those were worth about £11,000. Again, Ms. Henderson's executor applied to court to ask for about half of the value of the shares to be transferred to the niece and nephew. So in Snowdon, we had some named charities, and in Henderson, we just had charity generally. Now, in the High Court, everybody agreed that there should be a power to authorise charity trustees to make ex gratia payments. So unsurprisingly, Mr. Justice Cross agreed. He confirmed that the Attorney General and the court have the power to authorise charity trustees to make ex gratia payments. But, and this is the most important part of the judgment, he said it's a power which is not to be exercised lightly or on slender grounds, but only in cases where it can be fairly said that if the charity was an individual, it would be morally wrong of him to refuse to make the payment. Now, this test is phrased in the negative. The question is not what's the morally right thing to do. The question is it immoral for the charity to do nothing? In his judgment, the judge also distinguished 2 different situations. On the one hand, the situation where the donor or the testator never intended the charity to have that much money. On the other hand, a situation where the donor did intend that, but it's their family who claim the gift is not morally justified. The judge said in the first situation, you're much more likely to justify an ex gratia payment, and in the second, it would be rarer. Now, in the judgment, the judge acknowledged there was a concern that allowing this type of situation could lead to a floodgates type situation. In fact, the floodgates weren't opened, although in the 7 months following this decision, the Attorney General authorised 5 different ex gratia payments. Those numbers increased over the 1970s, and now the Charity Commission receives about 50 applications a year for ex gratia payments. So it's pretty common, but not very common. Those are the basic principles, though. But what factors can charity trustees take into account when deciding whether it would be immoral not to make the payment? Well, that's obviously a highly fact-sensitive issue, but I can make some general points. Firstly, the stronger the evidence of the testator's intentions, and the stronger the evidence of the reasons why those intentions weren't given effect, the more likely there is to be a moral obligation. obviously. Secondly, though, if the claimant has a good legal claim against a third party, this can reduce the moral sensitivity or even negate any moral duty at all. For example, the claimant might have a claim in professional negligence against the will drafter, or there might be claims against the estate under the Inheritance Act of 1975, or maybe even proprietary estoppel. Thirdly, the trustees should, of course, consider the position of the charity, and in particular, whether the charity can afford to make the payment. But it might also be worth considering any potential tax consequences of a charity making a payment that is not for charitable purposes. Fourthly, trustees can take comfort from the fact that the law recognises that different charities will interpret the requirement of a moral obligation in different ways. In other words, it is perfectly possible for some of the charities named in a will to think there is a moral obligation, and other charities to think there's not. So trustees shouldn't feel pressured by what other charities are doing. Fifthly, that's because, by definition, trustees are not under a legal obligation here. We're only talking about moral obligations. It's important not to lose sight of that. And finally, it may be possible to make a partial payment, for example, to reflect a weak claim or an unquantified claim for an ex gratia payment. Overall, charity trustees must walk a bit of a tightrope here. On the one hand, they can't be overly legalistic and unsympathetic because that's bad for PR. On the other hand, they can't be overly generous because that just invites more claims and could potentially be a breach of their duty. So this isn't easy. But I'll try and give you some more examples to help work out what is and isn't okay. The vast majority of ex gratia payments are made out of a deceased person's estate, but it is possible to make ex gratia payments to people who are still living. For example, if a donor makes a gift to a charity, mistakenly believing that they can afford that gift, but in fact the gift tips them over into poverty, you may be justified in making a payment back. This type of argument gained quite a bit of traction in the pandemic. Another example would be if the donor made a gift when they were not medically fit or they were emotionally distressed, but they still had capacity. And as a result, they miscalculated the amount of the gift or the impact it would have on their life. Now, as you can see, these are quite specific situations, and it's quite hard to come up with examples, but it is possible to make an ex gratia payment outside of the will's context. Continuing in the theme of examples, the Charity Commission has published a list of 32 examples of ex gratia payments which it authorised in the period 2005 to 2014. I've put the note on the slide and you can skim through the examples yourself, but I think there are 5 useful overarching points. Firstly, all of the examples involve wills. Secondly, 60% of the examples involve either someone dying before they could execute their will, or someone executing an informal document which wasn't a valid will as a matter of law. So that's the majority of all cases. Turning to the money, the examples show payments ranging from just over £1,000 to nearly £250,000. But that's a bit misleading because there were only 3 payments in the list that exceeded £100,000, and the average amount of money in the list is about £46,000. Also, when quantifying a potential ex gratia payment, it's possible to do so by reference to a particular asset. For example, a house, a mobile home, a car, a field, some shares. These have all been used as ways to quantify the appropriate amount of money. So if trustees are considering how to quantify a claim, you can think practically. So that's the test for making an ex gratia payment. I'll now turn to the practicalities and discuss the 3 ways in which trustees can get approval for their proposed ex gratia payments. Originally, only the Attorney General could authorise an ex gratia payment, but in 1992, the Charity Commission was given a statutory power to do so. And in practice, trustees should now usually apply to the Commission first. The only situation in which that might not be appropriate is if the gift is to charitable purposes generally, and there just aren't any obvious charity trustees to make the example. Then the executors might need to apply to the Attorney General. But let's say you are with the Charity Commission. The Commission must act under the supervision and guidance of the Attorney General. So, for example, the Attorney General might require the Commission to refrain from acting in certain situations, or might require the Commission to consult the AG in certain cases. Also, the Commission is under a duty to refer a case to the AG if the Commission thinks that would be desirable. Now, in practice, this rarely happens, but it might work if, for example, the case is particularly important or difficult, or raises a general point of principle or practice. But let's assume we're staying with the Charity Commission. The application needs to be made through the online application form, and I've put the link on your slide. The application should be made by the charity trustees and not by the person who wants to receive the money, or, for example, the executors of the will. Technically, each charity involved needs to make its own application, but if there are a group of charities relating to one will, they can nominate the same person to effectively conduct the process on their behalf. In practice, one of the larger charities is often willing to agree to be the lead charity here. So that's how. The application form also requires you to submit various pieces of evidence with the application. In a wills case, you should submit any relevant wills or codicils and grants of probate, and also any relevant draft wills or codicils. If it's not a wills case, you should submit details of the proposed payments and the circumstances which have led to the proposal to make an ex gratia payment. You also need to file an explanation from each charity of why they believe they're under a moral obligation to make the payment. Now, this doesn't need to be a formal witness statement or statutory declaration. A letter or email would suffice. You also need to file a copy of the minutes at which the trustees decided to make the ex gratia payment. Most importantly, the Commission expects firm evidence that the donor's or testator's intentions have been frustrated in some way. Now, in practice, this usually requires you to obtain statements from an independent person, like a solicitor or a friend of the family, or contemporaneous written statements from the donor or testator themselves. It's not usually enough to rely solely on a statement from the person who wants the money. Finally, if the charity's taken any legal advice on the ex gratia payment, that should also be filed with the Commission. Once the application's been filed, the Commission will ask itself two main questions. Firstly, have the trustees established a convincing case that they believe the charity is under a moral obligation? And secondly, is the decision to make an ex gratia payment within the range of decisions that a reasonable body of trustees might take? Now, in practice, it will probably take some time for you to hear back, because the Commission's internal guidance is that all applications have to be considered by a legal member of the senior management team. If the Commission does approve the payment, it will make a formal order, which it will send to all of the charities involved in the application. Those charities should keep that order because they may need to show it to their auditor, and in some cases, they may need to disclose details of the ex gratia payment in their annual accounts. If the Charity Commission refuses to authorise the payment, you can't yet appeal that to the first tier tribunal, but instead, you can just make a fresh application to the Attorney General. So let's turn to that now. If the Commission rejects your application, you can apply to the Attorney General through the Treasury Solicitor. This is not technically an appeal, so the Attorney General will consider the matter afresh. The AG doesn't publish any guidance on how she considers these types of applications, but in practice, she will probably follow the guidance in Snowden and consider similar, if not the same, factors to the Commission. If the amount at stake is large or there are some unusual factors in play, then technically the AG can ex parte apply to court for directions, but that's pretty rare. So our second option is the Attorney General. Our third option is that the court can also approve an ex gratia payment. However, this again will be rarely appropriate. In fact, as far as I can tell, in the last 55 years, there have only been 3 reported cases concerning ex gratia payments. Snowden, where this all started, the British Museum case in 2005, and an Irish case concerning the Presbyterian Church in Ireland from 2011. And there are a couple of reasons why this rarely goes to court. Firstly, practically, trustees get 2 bites of the cherry with the Commission and the AG before they even need to consider court proceedings. And secondly, if you do want to go ahead and issue a claim in relation to an ex gratia payment, that will count as charity proceedings under Section 115 of the Charities Act. That means the charity needs permission from the Charity Commission to even start the claim. And in practice, the Charity Commission is unlikely to give you that authorization unless and until you've applied to both the Commission and the AG. And if both have refused, you may have an uphill battle persuading the Commission to give you that permission. So that's what the law is today. But what about the future? In this final section, I'll explain the 4 key changes that the Charities Act 2022 will soon introduce in this area. Now, overall, these changes are designed to give charity trustees greater autonomy, subject to appropriate safeguards, to make ex gratia payments. Unfortunately, it's recently been announced that the implementation of these new pieces of law will be delayed while the government considers the impact for national museums and galleries. From the limited information we have so far, it seems like the government may tweak the law so that you can't make an ex gratia payment to anyone outside the UK. Now, if that was the case, that might be a problem for international families in will cases or international donors. Also, the Charity Commission hasn't yet updated its guidance to reflect this new statute, so we are a little bit in the dark here. But nevertheless, we have the terms of the Act and the Law Commission's report. So let me explain to you what it currently says. The most important change is that charities will be given the power to authorise their own ex gratia payments up to a certain amount. They can do so if, in all the circumstances, the charity trustees could reasonably be regarded as being under a moral obligation. Now, that's an important change. Previously, the test was subjective, what the trustees thought. Now it's objective, what the trustees could reasonably be regarded as being under. The amount which any charity will be able to make as a payment without authorization depends on the charity's income in the last financial year. I've summarized the figures in the table, but you can see that generally it's pretty modest. For example, for a small charity, you can only make an ex gratia payment of £1,000. Now, these income bands should look familiar because they're the same income bands that are used in accounting purposes. When this law comes into force, there will be no limit on the number of ex gratia payments that a charity can make in any given year, so this could be practically very useful. However, while the new law will simplify smaller ex gratia payments, there could be 2 potential practical problems. Firstly, where the statutory power applies, the Commission is likely to be reticent to authorise any small ex gratia payments for itself. In practice, this may make it difficult for charities to rely on the common excuse, we can't say yes because we need to go to the Charity Commission. In turn, there's a concern among some charities that this could lead to an increase in the number of claims for an ex gratia payment. One way potentially around these problems would be to exclude the power to make ex gratia payments in the governing document. If you exclude it, then as usual, the trustees would need to obtain authorization from the Charity Commission or the Attorney General in every case. So that's one potential way around those 2 possible problems. The second change that will be introduced is that trustees will be allowed to delegate the decision to make an ex gratia payment of any size. Technically, under the current law, only trustees can make the decision because the statutory test, which the Commission applies, asks whether the trustees believe the charity is under a moral obligation. In practice, though, we all know that many charities have long delegated these decisions to legacy officers. To bring the law up to date with practice, the test will be changed, so the Commission will ask whether the trustees could reasonably be regarded as being under a moral obligation. We've seen that test before, haven't we? Again, it's a change from a subjective test to an objective test. But practically, this change to an objective test really emphasizes the importance of getting clear and independent evidence of the moral obligation. because it's no longer a question of what the trustees believe, it's what they could reasonably be regarded as being under. The third change which the 2022 Act will introduce is that it will soon be possible for charities which are established or governed by royal charter or statute to make ex gratia payments. This is designed to reverse the decision in the British Museum case that I mentioned a short while ago. That case held that a charity which is incorporated or governed by statute is simply unable to make ex gratia payments. In practice, this change is likely to affect only a small number of substantial charities, many of them national museums. Also, it's a little bit unclear how this provision will work with charity legislation that was passed between 2011 and 2022. But those quibbles aside, this will probably be quite useful for some charities. The final change that I want to talk to you about is that the Charity Commission's decision to refuse to authorise an ex gratia payment will soon be appealable to the first-tier tribunal, like many other decisions. In practice, this will open up a fifth route to getting approval for an ex gratia payment. The Commission, the Attorney General, the Court, the trustees themselves, and now the tribunal. Now, the tribunal will need to work out issues like who has standing to appeal such a decision and what test should be applied. But it's fair to say that looking at matters in the round, the future's looking pretty bright for ex gratia payments. Thank you very much for listening.
Yep, I think that will bring us to the end of today's session then. Hopefully everyone has enjoyed it, learned something, and we're very glad that you could all join us this morning. If you do have any other comments, then you can find our email addresses on the website. But thank you very much and have a great rest of the day.
Thank you.
Bye.